I'm wondering whether we should just start. I've been trying
Oh,
to get
I've
in.
had a lot of trouble trying to log in.
Yes. Somebody's logged in there. I think that might be Steph. It's coming up as iPad CQU lease. Is that Steph? Hello, is that Steph there?
Oh, hi. Yes. Can you hear me, Peter?
Yes, I can. And we've got Crystal here. We've had Robert logged in for a little while, but I haven't been able to speak to him. I'm not sure what's happening. It's telling me that his microphone is on, but I haven't had any response from him. Okay. So I'm thinking in view of the time, it might be an idea if we go ahead. I've been trying to get in touch with Robert for a while, so hopefully...
Your sound has just cut out.
Oh, has it? Well, in that case, what I might do is I'll turn off my video. That will reduce the bandwidth. Okay? Might not help. Can you hear me okay now?
I can hear you.
Crystal, can you hear me? Crystal? Crystal, are you there? Crystal, can you hear me now?
Yes, sorry, it logged me back out again.
It did it? Well, that's unusual. Did it bring up any message? Crystal, did it show up any message when it logged you out?
It took me back to the home page and it just had the waiting logo flashing.
Oh, right. Okay. Well, that sounds like a disconnect. The reason I asked is that once in the past, another teacher tried to log on as the person running the meeting while I was logged on, and that happened, but it had a very specific message and I got the message, so I don't think that's happening now. So I've got Steph and I've got Crystal here. It looks as if I haven't got Robert in audio contact anyway. If Robert can hear me, he could post something to chat to indicate that he's actually there listening anyway. It's showing me Robert's microphone is working, but I'm not getting any responses from him. I'm thinking in view of the time that we'll need to go ahead here and get started. I'm thinking with problem one, this is a key area of practice where in the optimistic initial stages of a business or of a small business turning into a slightly larger business, the clients come to you and they discuss potential business structures. So this is a very important area for practice. Now, can one of you sum up for me briefly the problems with somebody acting as a sole trader? What's the downside of that?
I think the liability is the main concern with sole trading. Even though you get complete control of your product or your business, you've got unlimited liability? Yes,
that's right, unlimited personal liability. So in other words, you're just governed by the ordinary law of contract. If your business incurs debts that the business can't pay, then you end up having to pay them personally, which could mean selling your house or the creditors selling your house or you going bankrupt. You mentioned that you do have unlimited control as well, and that's without doubt a useful thing. Can you think of something else, not just liability, but can you think of some other difficulties that might arise as a result of being a sole trader? I'm thinking of practical things, remembering that when clients come in, they don't necessarily distinguish their practical problems from their legal ones. Can you think of a typical practical problem for somebody setting up a business and running it all on his own? Crystal, do you have an idea on that?
Possibly just running it on your own. As simple as that sounds, like I guess with a partnership, you've got someone else there, maybe and 2 or 3 people. We've set up a couple of partnerships that work at recent times, and it sort of eases the load. You can take different, jobs within the business, but as a sole trader, you're the person. You're responsible for managing it, for doing the accounting sides.
Yes, I think you summed it up. The first part of that, the audio was a bit distorted, but I picked enough up, and particularly the last part I picked up. I think you've hit the nail on the head that when you meet a lot of small business people, a very typical situation is that they don't want to be employed by somebody. They're sick of having a boss, so they want to do their own thing, but in their own business. The trouble is that running a business requires more skills than just the skill of doing the actual service you provide or selling the merchandise that you sell or some such thing like that. And it's amazing how unsuited small business people can be to those other tasks. You've mentioned bookkeeping. Marketing is another one that small business people are hopeless at. In fact, even ordinary things like client interactions, they're often not all that good at that. When you're an employee, you're a little bit shielded from that, because if the client doesn't like you or the customer doesn't like you, well, indirectly you might get a little bit of bad feedback about that, but you don't lose your job or anything like that. But in business, of course, you do lose work if you can't get on with customers. There's one other form of sharing that can be a problem for a sole trader. Can you think of what that might be? The absence of sharing. It might even be, Crystal, that you mentioned it and we missed it at the start. Apart from the ability to share work through shared skills, can you think of something else there? Have you got any ideas, Steph? You're about to say no, are you? It's Crystal, you're about to say no, were you?
Yes, I work in a legal firm, and we don't have a lot of practice setting up sole traders. We set up a lot of companies and a lot of registering business names and partnerships, but I don't have a lot of exposure to sole traders.
Right. I'm afraid
Actually, I've just thought of something. I'm not sure if the audio is coming through okay. We did a seminar last week, and I guess the difference between running a sole trader is sometimes could be intertwined. We did a seminar last week on it, so I'm not sure to play as well.
Right. Well, I must say that some of that audio was distorted there. I'll switch over to Steph. Are you there, Steph?
Yes, I'm finding Crystal's audio is distorted. The words get stretched out so long, it sounds quite electric.
Yes. I thought you might be getting that. I'm not sure if that's. It must be a poor connection or some such thing like that, but that's okay. The thing that I was thinking of was finances. It costs money to establish a business, and of course you need capital to run it in the initial stages. It'd be typical in a business that it loses money at least for 6 months, and some businesses are set up so that they're not going to make profits for a couple of years, and so that needs a fair bit of upfront capital. And sometimes someone who has a skill or it could be a good business idea, a good venture, or a good proposal, or some such thing like that, doesn't have the money to carry it through. So he's got the skill or the know-how, and he needs a business partner to contribute funds. So that can be another form of sharing that's necessary for business, and it can be a problem for a sole trader. Which leads us into this second idea that, well, then of course you move into partnership, which overcomes some of those difficulties. Steph, could you suggest to me one difficulty that partnership does not overcome?
Well, I'd say partnership still has the same problems as sole trading if one or both of the partners passes away, dies, unless they make provision in their will. Is that what you said?
Yes, well, it's true that both of those situations would be problematic in a sole trading situation. Effectively, the business, once a business stops trading for a while, it loses its goodwill and effectively is no longer a business. It just becomes a bunch of static assets, assuming that it has any assets. Some businesses run on leases and things, so they wouldn't have even had any assets. Now, so if a sole trader dies, it's rare that you can just sell off the business quickly through the executor and sell it as a going concern. So that's a problem. It's true that the same sort of problem arises with partnership. It's not quite the same though, is it? You have one partner left over, but it is difficult to replace the deceased partner easily because bringing in a new partner involves a new partnership, and the new partnership would have to purchase the business from the old partnership. So there are difficulties there. Exactly how, normally, to some extent, a partnership deed tries to overcome these things. You can have in partnership deeds provisions for the death of a partner or some such thing like that. I was actually thinking a more obvious difficulty with partnership. In fact, the most important difficulty with partnership compared to companies, for example, which is shared with sole trading. The same problem as with sole trading. Can you think what that is? Robert has suggested shared liabilities, and he's on the track there. I'm not sure, Robert, what you mean by asset liability. Can you elaborate that a little bit in the chat window? I take it that the others have the chat window open as well. Ah, I see what you mean. Yeah, that's exactly right. But the key problem with partnership is in some ways the same as sole trading, that you've got unlimited personal liability. And that means that your own personal assets are exposed. In some ways in a partnership that's worse, because in a partnership your partner can commit you to liabilities without you knowing about them. So if your partner goes off and enters into a contract that you don't necessarily agree with, or you might on the surface agree with it, but he hasn't actually done the proper due diligence and inquiries about it, so it sounds good on the surface, but then when you look into it, it's not. You can actually have unlimited personal liability for a liability that you didn't even incur yourself. And so the unlimited personal liability aspect can actually be worse for partnerships than for sole trading, despite certain sharing benefits of partnership. I might say that partnership breakdowns are almost as bad, in fact, sometimes worse than divorces if you're handling them. Partnership breakdowns can be extremely vicious, and they can be quite challenging to handle in practice as well. So that's the other side of the coin of sharing the burdens of a partnership. When the business gets in trouble, you find that the the personal relationship between the partners will very frequently break down and resentments will arise. There'll be an element of finger pointing. They'll start doubting, inevitably, if the business is going downhill. The actual business that's been written by the partners is failing, which means that somebody was responsible for doing that business within the partnership, and resentments can arise in relation to that. Or if one partner is doing the marketing and another one's doing the work, if you don't have enough business coming in, the marketing partner will get blamed for that. He's just as likely to say to the other partner who's doing the work, well, the reason the customers are not coming back is because you do a poor job, or some such thing like that. Or he'll complain that the person doing the work doesn't do it fast enough, or some such thing. Or the person doing the work might say, well, we need to charge more. And the marketing person typically doesn't like to do that because it's harder to get business if you're charging more. So those sorts of disputes tend to surface in when partnership businesses start failing. Now, those personal issues can't be overcome, but of course, when we get into companies, the major benefit of companies is limited liability. And just as a quick quiz question, can one of you tell me whose liability is limited in a company?
The directors.
Well, they generally don't have liability. Robert's got it. The shareholders, they have limited liability. So the directors tend to have no liability. The shareholders have limited liability. That's where the term comes from, because their liability is limited to the price of the share, the issue price of the share. So that's where the term limited liability comes from. The main point being that a company itself does not have unlimited liability at all. Limited liability at all. A company, being a legal person that incurs debts, has unlimited liability, just like any legal person. But the benefit, of course, of a company is that it's an artificial person. So if you're a real life person incurring debts and you can't pay them, well, then your personal assets are exposed, and you have the emotional and family issues that go with that as well. Whereas if a company is only an artificial person running a business, so if its business assets aren't enough to cover its debts, there's no downside to the company itself. It just goes into liquidation, and all the other real people that were dependent on the company, like the creditors in particular and the employees, they're all the ones that suffer the backlash from a company going broke. So that's the major attraction of a company. Can you think of any practical disadvantages of setting up as a company?
All the frameworks, all the legislation to abide by.
Yes.
And the regulations.
That's right, the regulatory requirements. That's probably a fair way of summing it up. You've got the costs of setting it up and the costs of running it. We'll see when we go through the course, you'll see what the regulations are for various things. But even at the most basic level, you have to have directors' minutes. So even if it's a company like Salomond's company, you'd still have to have minutes of directors' meetings and things like that in order to carry out your regulatory obligations. And there are certain things they have to file each year with ASIC and stuff like that. Robert has said loss of control. That certainly can be the case if you're a group of people going into a company and investing in a company and you're not on the board. Or I suppose effectively the people on the board could arguably act like partners and share control, but any of the investors who's not on the board would lose control as well. But the main downside in practice that people say to you is the actual cost of running corporate structures. There is, for small business, there is an ongoing cost. In terms of control, if you're worried about control, you can set it up in a way where you do have control. You can set up in a way where where each of people are entitled to appoint themselves as directors or something if you're really worried about that. Now, okay, so those are the basics I wanted to go through at this early stage of the course. Yeah.
Can I just ask a question?
Yep.
Is it a fine line between a partnership and a joint venture? I'm gathering that a partnership is for the purpose of making a profit, whereas a joint venture, I'm just wondering, how do we differentiate? That joint venture apparently is more riskier.
No, you're on the right. No, you're on the wrong track there. There's a definition in the Partnership Act of a partnership, and it's along the lines of that persons carry on a business in common with a view to profit.
Yes.
Now, if that occurs and it's not set up as a company, then it will be ipso facto a partnership. Now, normally that situation will arise through an agreement, but sometimes the agreement is unspoken. It's just sort of implied through conduct, and the Act doesn't specifically require an agreement. It's just that in order to carry on a business in common, you really have to have agreed to do that. Inevitably, you must have agreed to do that. Now, the difference with a joint venture really comes into that definition. In a joint venture, the parties to the joint venture take part in an overall project, but their business interest is different. So it's not a business in common. So I often give the simplest example of a joint venture, even though no one would use the term in relation to it, is a taxi, where the owner of a taxi delivers the taxi to the driver with the tank full of fuel. The driver goes out and does his business. He pays to fill up the tank, the petrol tank, with the takings from the fares, but otherwise all the costs are borne by the owner, like the insurance, the repairs, stuff like that. The driver comes back from his shift, he delivers the car back with a full tank of petrol, he cleans it up, which is called detailing, and delivers it back to the owner, and then they share the takings, often 50-50. Now, if you look at it, apart from the petrol, the expenses are not shared. The expenses are paid for by the owner of the cab, being the cab and the license, the taxi license attached to the cab. So it's not a business in common. Even though it's a business of running a taxi, the owner's business is different from the driver's business. And so that's more like a joint venture. Even though no one would call a taxi a joint venture, you tend to call bigger things joint ventures, but it is more like a joint venture because each party has a separate, discrete interest in the business. They typically don't share the profits. Remember, the idea of sharing profits is different from sharing gross returns. Sharing profits means effectively that you're sharing revenue and you're sharing expenses, because profits is the difference between revenue and gross revenue and expenses. Now, in the taxi situation, most of the expenses aren't being shared. So in a typical joint venture, the parties get a share of gross returns, but they have their own separate expenses. To move that example up a bit, you might have a mining joint venture where you have one big company that's good at running mines and another company that's good at doing all the transport related to mines. You know, those big trucks, and sometimes they build big railways and things like that. In Australian mines, often the transport angle involves transporting ore hundreds and hundreds of kilometres to the port or something like that. Now, you might set up a joint venture there where one company agrees to do the mining bit, another company agrees to do the transport bit. They take a share of gross returns. It doesn't have to be 50-50. Partnership doesn't have to be 50-50 either. They agree on some share of the gross returns, but each company has their own costs. They've got their own staff, their own on-costs of running their part of the operation, and so what they net out of that will be discrete amounts, are not necessarily related to their share of the gross. And that would be a typical joint venture. So the typical distinction between partnership and joint venture is that joint venture is not a business in common. It's a venture in common involving separate businesses for each party and separate interests and separate liabilities.
Well, you've explained that really well. Thank you. Just puzzled me for so long. Thank you.
One of the things that Robert, I wish we had Robert on mic because he's mentioned something about the fishing industry, and I don't actually know the fishing industry well enough to know the joint venture example of that. I'm just in my mind trying to quickly think what that might be. I'm just not sure offhand what that might be, unless somebody owns a boat and they allow people to use the boat and share the takings. That sounds like share the catch, so to speak. That sounds like it could be similar to a taxi, but I'm not sure. Is that what you're meaning, Robert? Right, the master and the deckhand share the catch. Yeah, so again, that's sort of a gross thing, isn't it? And they'll have their separate costs. I think, I'm not quite sure of the role of the master. I think the master represents the owner on the ship, don't they? And the deckhands, they share the takings, and the master represents the owner, and the owner bears the cost of the trip. But something like that certainly would be an example of a joint venture. I might say that the word joint venture isn't a term of art in law. So you'll see, for example, in the Canny Gabriel case, which is the leading case on joint ventures and partnerships, they refer to it as being a joint venture, which is a partnership. That's a case I think it's from the early 70s. It involves a concert tour of Elton John and Cilla Black. So those of us my age know who those two people are. But they were in the 1970s. Obviously, people still know who Elton John is, but a lot of people don't know who Cilla Black is. She was famous singer in those days. They came out to Australia, and a joint venture was set up between the financiers of the concert tour and the promoters. And the court held that the amount of control that was given to the financiers amounted to a partnership. And the court referred to it as being a joint venture, which satisfied the definition of a partnership and therefore was a partnership. Since the 1970s, and this has been an academic thing, in textbooks, to draw the distinction that I just drew, they started using the term joint venture to mean what I just described, something that's not a partnership. But it's not really a term of art. There's no act that says this is what a joint venture is, or no string of cases. But in modern cases, they'll tend to use joint venture in the way that I just described.
That's great. Thanks.
I'm not quite sure if I'm understanding Robert's question there. Have I missed something?
Isn't she a dame now?
Who's that? Have I missed something here? Oh, Cilla, sorry. I was a bit worried there for a moment what you were talking about. Yeah, Cilla. Actually, I don't know. She probably would be. They tend to knight their entertainment personalities after a while, don't they? Yeah, I'm not quite sure about that. You're showing your age, though, Robert. If you're up to date with Cilla Black. Now, I'm a little bit conscious of time. I think that we can handle it, though. And incidentally, I know that one or two of you might have to go off at 7, but I'm happy to field a few questions after that as well. There's no urgency to it. I'm thinking about, we're looking at this Salomon case and the Lee case. Now, have you all read those cases, or at least acquainted yourself with what happened in those cases?
I have with Salomon. I'm still sketchy on the Lee case.
Right. Well, we have another go at Crystal. You're there, Crystal? Can we see whether your audio is working again there?
She's not in the list of participants.
Oh, she's still in my list. No, she isn't. She's gone. No, she's gone. You're right. Okay, she might have had to go off. Okay, well, we'll proceed. It seems odd now, but I was reading over what was said in the lower courts in the trial and the Court of Appeal in Salomond's case. In both those cases, the judges, including some very experienced judges, were extremely hostile to the idea that Salomon could do what he was doing. Steph, did you when you read over that case, does that seem strange to you, or does the case seem to you to be one that seems a bit unjust? Do you think it's unjust?
It seems unjust, just off the top of my head, in that this was a fairly new idea to incorporate, and he was just running a family business, and his wife tried to bail the business out before it went bankrupt. And she lost her money, and then they sort of the lower court judges created him, or the appeal judges, I think, created him, made him look like he was some sinister deviant, and all the goodwill he had in London, quickly went. Especially being Jewish, he was subject to some anti-Semitic feeling, I would assume. That's my feeling.
You've read a lot between the lines there, haven't you, Steph? I'm normally criticising students for not reading between the lines of cases, but you've read a lot into that one. But I don't necessarily think you're wrong.
Okay.
But in looking at it from a modern perspective, isn't this the sort of thing that modern companies do all the time? So I'm not sure whether you were saying from a modern perspective or looking back perspective, but if you saw a businessman doing that today, would you bat an eyelid at it?
No,
Robert,
not today.
Yeah, Robert, you might like to put in an answer on that as well. Does this behaviour seem strange or unjust, I think, to be more accurate? Yeah, currently accepted. It does seem to me that when you read Salomon's case, it's whenever I read it. In fact, I read it regularly, in that I teach it constantly over the last several years. But whenever you look back on it, it is interesting to see how attitudes change, isn't it? And you can see that at the time of the case, this whole idea of being able to do this, and the thing that really seemed to stick in their craw was the idea that this really was a one-man business. That was what concerned them. It's a one-man business. Sure, there was a Companies Act or Joint Stock Companies Act or whatever it was called that said you had set up businesses with 7 shareholders, but it did have a minimum of 7. And I think part of the thinking was, well, if the Parliament requires you to have 7, well, the intention is that this is for businesses run by groups of investors. And so if you look at it from that perspective, it does seem a little bit odd that you could just get around that so easily by selling £1 shares or issuing £1 shares to a bunch of relatives, and then the minimum of 7 shareholders requirement then becomes a bit of a furphy, doesn't it?
Mm.
But I think that was why they thought it was extraordinary in the Court of Appeal. They just thought, well, this is just getting around the Act. That in the House of Lords, of course, they thought, well, this is what the Act says. It doesn't say that the shareholders have to have any interest or control of the business, and so all he's done is what the Act provided for. But I think that was the thinking, that if Parliament really wanted you to be able to set up one-person companies, why didn't it allow you to have 1 shareholder and 1 director? That was, I think, the thinking at the time. But once that case got through the House of Lords, of course, it was then open slather. And setting up companies with dummy shareholders was routine. In the original companies codes, there was a requirement of 7 shareholders. Then for most of my life, there was a requirement of 2 shareholders, and now you can set up companies with 1 director and 1 shareholder. So they can literally be one-person companies. And that had the benefit as well that you didn't have to put in fake appointees to directorships when those directors were like spouses who took no part in the company and didn't really carry out their duties properly. Now, having said that about Salomon, Salomon's case was decided a long time ago. Why was it necessary for Lee's case, or why do you think it was necessary for Lee's case to have to go to the Privy Council when Salomon's case had already decided all this, hadn't it? Could you see in Lee's case what the difference was?
Well, I got a bit stumped. It's similar because he was the pilot, Salomon was the bootmaker. So something to do with contract?
Yes. The contractual bit is a bit straightforward. Under workers' comp legislation, particularly the original versions of it that were around in 1961 when this case went to court, you had to prove that you're a worker or a workman. Different legislation used a different term, but let's say worker. For workers' compensation, you had to prove you're a worker. And the primary way of doing that was a contract of service. In other words, what we call now an employment contract. I'll mention the fact that the alternative to that is an independent contractor who provides services as a contractor, not as an employee, and that's called a contract for services. And I mention that because the case uses that old-fashioned terminology, which is not obvious. So the case, amongst other things, the Privy Council said, if you can have a contract for services, in other words, an independent contract with a company, why can't you have an employment contract, a contract of service? Now that argument seems to me to be fairly patent. So I can't see why it was necessary for this to go all the way to the Privy Council. But the argument that was put was that, well, this is a master-servant relationship. Again, this is old-fashioned terminology. We'd call it an employment relationship now. But in those days, it was called the master-servant relationship. And the difficulty that the lower courts had was this argument that, well, in order to have a master-servant relationship, you have to have a position of dominance by one person over another. And how do you do that when the person who's acting for the company is the same person who's the employee? And the court still seemed to struggle with this argument right up till 1961, until it was decided by the Privy Council. So that's getting more recent. It's just barely within my lifetime, but it is within my lifetime that they were still struggling with this idea that seems fairly straightforward now. So since those cases, though, this position of the company being a separate legal entity and people acting in different capacities, both as employee and as director or agent of the company, as an agent as the boss for the company, but also as an employee negotiating with the company, the law clearly allows that. The other thing I think that they were troubled by in that case was the idea that the company could negotiate a contract with the employee when the person doing negotiating for the company was the same as the employee. In other words, Mr. Lee was negotiating with himself. That was another concept that they had difficulty with. But as I said, in the end, they got there and went to the highest court to do that. I think that might have been a New Zealand case going to the Privy Council there. Privy Council was made up of the same judges who were on the House of Lords. They just wore a different hat. So on appeals from the Commonwealth countries, the appeals went to the Privy Council. What they're called the Law Lords, or actually called the Judicial Committee, of the House of Lords, they were the same judges on both of those courts. It's just appeals from the colonies went to the Privy Council and appeals within England went to the House of Lords. So that means that the authority is unified there. Maybe not in a doctrine of precedent sense because you've got two hierarchies, but in a practical sense, you're getting the law handed down by the same judicial committee in both cases. Now, to finish up, I just wanted to, at least on that, I wanted to just point out to you to reflect on how the idea of limited liability is interwoven with this idea of separate legal entity, isn't it? Because in order to grant limited liability to the shareholders in a just way, at the very least, you have to have some legal person who doesn't have limited liability. So I suppose it's not essential, but practically speaking, it's essential. In a policy sense, it's essential to have some balance of fairness, that the company undergoes the personal liability, which is unlimited, and that allows you to have an artificial construct where the real people behind the company can have limited liability. So it's useful to reflect on the fact that separate legal entity is important to the idea of limited liability, because and that's important because the benefits, the society benefits of companies relate to the ease of investment arising from that limited liability of the investors. Another point I might raise with you, or get opinions from you on, one simple, maybe people would say simplistic way of putting it is that all you do by setting up a company in this way is you shift the risk from the investors to the creditors. Do you think that's a fair comment?
Now, this is interesting because I am struggling to find, I haven't done a great lot of reading, it's only week 2, but why the creditors in Australian corporate law seem to be the ones who lose out. They're the ones who sink first, or they don't always get their return. I've just been looking at the American law and understand that creditors have, if they can prove that there is fraud, or if the creditor itself can actually prove that the company has defrauded them, or that they actually can regain their money. Whereas I'm a bit confused by this all. Sorry. Yeah. Are you getting my gist?
Yeah, I am, and I'll be interested to see what you contribute on that point. That'd be an interesting point on this assessment 1. Robert is mentioning the fact that companies need tight regulation. And that's, of course, how we try and do it in our system, that we try to observe the exposures and protect creditors where we can. And there are some innovations there, things like the duty to avoid insolvent trading. You haven't studied these things in the course yet, but there are a number of regulations that we do look at throughout this course that look to protect creditors in various ways, the insolvent trading provisions being one of them. I'll be interested if you come up with some more advances in American law. I'd be interested to see what you have to contribute on that. Robert's also raising the fact that the argument in relation to creditors is that they can negotiate a contract on the terms that they want. And one of them is the one that Robert's raised, that the creditors dealing with the company, not just banks, other creditors can, if they give credit, they can also require directors' guarantees and things like that. And that sometimes happens. But there are two areas where that's a problem. One is where the transactions are more or less instantaneous, one-off transactions. When banks give loans, that's sort of a long-term contract involving multiple payments. So it's practical to, there's an actual negotiation phase of that where you can stipulate terms, and banks do stipulate guarantees and securities and things like that. Also, I've seen it when tradespeople get accounts with trade suppliers. Sometimes those trade suppliers require personal guarantees in order to give them accounts. It's a benefit to the tradesmen because they can go off and order all the materials, or not just order them, they can actually buy them on the basis that they pay later. And of course, what they try to do is do the work, incorporate the materials, and get paid for it themselves before they have to pay their supplier. And so suppliers sometimes get personal guarantees and securities and things like that as well. That's one argument. But the problem there is, in relation to contractual liabilities, it's only really practical to have a negotiation phase where the transaction is a long-term or repetitive relationship. A bank is a long-term relationship, money paid off over periods of time, or a long-term line of credit or something like that. Trade suppliers is long-term credit arrangements as well. But if you're just doing a one-off transaction, it's not really practical to negotiate and organise securities and things like that. And that's where creditors can get caught. And of course, there are situations where creditors just don't have the bargaining power to do that as well. That's a bit of an iffy situation. You mean, some people would say, if you don't have the bargaining power, you don't have the bargaining power. That's capitalism. That's the free market. The reason you don't have bargaining power is because there's another bloke down the road who's prepared to give this credit arrangement with no security. So if you were a trade supplier and demand that the tradesman gives you security, well, he might say, well, I'm not going to deal with you. I'll go down the street to somebody else who'll give me an account with no security. So there are issues of bargaining power, but some people would say that's not a real complaint because that's just part of the system at work. But the other area is tort liability. For example, Hardy Brothers and their liability for asbestos claims. They tried to evade those by just getting a new legal entity and allowing the Australian entity to wind down and shifting any assets they could over to the other entity, which was originally set up in Holland, I think. Since then, I think it's been shifted again in order to evade tort liability. And you can't say that people who suffer from a tort aren't in a position to negotiate who their tortfeasor is. And so they're just stuck with the idea of limited liability. Robert's saying his experience is the bigger the company, the longer the time for payment. I think that's my experience as well. If you're saying that when you have a customer who's a big company, they have the luxury of taking longer to pay because they're seen as a more desirable customer to have. This happens with lawyers as well. Lawyers get paid very slowly. Their bills get paid extremely slowly, and I've seen that many times. That as a lawyer, you like to have a big company as your client, but they can be woefully slow in paying. They literally take a year to pay, and meanwhile you're paying huge amounts of overheads and interest on your overdraft and whatever in the meantime, waiting for big payments to come through. Now, Robert, you've mentioned tax liability. What's your point in relation to that? While you're contemplating that, oh yeah, I saw the headline today that Apple doesn't pay very much in tax, but I didn't read the detail of the article to see exactly how that was. In fact, when I looked closely at the heading, I wasn't sure that it was a small amount of tax because they were referring to their gross revenue rather than their profit. So relating the tax to the gross revenue is pretty meaningless. You'd have to look at what their profits were anyway. But it is interesting, though, that in relation to tax liabilities, the government doesn't accept the corporate veil all that readily. For example, if companies don't pay their group tax, that's the old-fashioned term is group tax, call it withholding tax now, I think, for their employees, the directors are responsible for that. So the tax, you can always find that the tax department, they have different rules in their act compared to everybody else. They don't tolerate all this stuff about people hiding behind corporate veils. So that's, I mean, it's an interesting aspect of power when you're the tax department. It's an interesting aspect of justice, that what's regarded as just for ordinary creditors is not regarded as just for the tax department. Now, did either of you have any more questions about that?
Just quickly, so when the directors run off and go and live in Brazil and leave people floundering, the media picks up stories of shareholders floundering. Is this what we're talking about, basically, that the directors might be giving personal guarantees for loans and investments, and then when they take off to another jurisdiction, they're not liable in Australia, basically, in a simplistic form?
Well, they would be liable in Australia. I'm not sure that the examples you're talking about are likely to have directors' guarantees. But the situation with enforcement overseas, there's two aspects. One is that to bring action against somebody, you've got to be able to serve them overseas. And you need leave of the court to serve outside the jurisdiction. Now, that in itself can be time-consuming and difficult, but it can be done if you can execute personal service. If you want to serve in a way other than personal service, that can be quite difficult to do. Basically, the courts don't allow you to serve they won't give you an order to serve in some other way unless they're satisfied that that will actually bring the proceedings to the attention of the person. So the fact that someone's overseas doesn't mean that there are lesser requirements of service. Once you serve the proceedings, if they don't defend them, then you can get a default judgment, and the problem then becomes enforcing the judgment. And that becomes a problem of treaties, that there are some countries where you can enforce Australian judgments by registering the judgment in those countries. And there are other countries that aren't part of the treaty, and so you just can't enforce in those countries. And even in the countries where you can enforce, it can be extremely difficult and time-consuming to do that, and costly to do that. Because, see, enforcing a judgment in Australia, you just literally register a paper in another state, for example, and enforce the judgment, because the judgments are recognised all over Australia. But if you go into another country, it normally involves you getting into court, actually having court appearances and things like that in order to enforce those judgments. So it can be extremely difficult to do that when directors are overseas. Does that answer the question you're asking?
Yeah, look, it's just something we're going to learn more about later on, I'm sure, so that's great. Yep.
Yeah, you might learn about it in practice and procedure. I'm not quite sure what your practice and procedure course is.
No, I've done civil procedure, and I understand about personal service, but I think my question was more how do these scammers actually find legal loopholes to do what they do?
Well,
I'll better leave that for another day, Peter, because better go off to my equity, my trust.
Oh, that's right. You've got another class on, so I better let you go then. Okay. Well,
I'd love
thanks
to,
for turning up.
If we could make another evening, so I don't have to race off.
Yeah, we'll get online and we'll work out another day for next week. It was just a bit late this week to organise another day, but we'll get online and organise another day for next week. So I'll let you go. Robert, are you going to be able to get a microphone for next time around? You there, Robert? That's good. Okay. Well, watch out for the discussion online on the Moodle site in the forum. We'll have a look at times for next week that hopefully will suit everybody better. Robert, did you have any more questions to ask me? Robert, I'll finish up this class here. Sorry, I've just seen that. Yeah, get on to watch the Moodle forums, and I'll try and generate some activity in students giving preferences for times. We'll try and organise times where people aren't limited by the amount of time. I'm not saying I want to sit here all night and talk about things, but you don't want to be cut off because people have to go to another class. So we'll try and organise better times and try and get more students here. The more people we can get talking, the better discussion. It was a bit of a pity with Crystal tonight that hopefully she seemed to have bandwidth problems. Well, hopefully she can sort those out. I'll get in touch with her about those as well. Okay, Robert, thanks for coming along tonight. I'll finish the class there, and I'll at least speak to you next week. See you later.